Great day, everybody. This is Zen. Today is November 17, 2020. And yes, I am back. I got an awesome topic for you today. But before we can get into that, let's go ahead and make our way to the screen here. Attention. Number one, if you need a video to be created based on a particular subject, please feel free to make contact. Number two, if you have questions that you need a bit more clarity and would like me to point you into the right direction, explicit and concise, please make contact. No donation is required. Number three, if you need private assistance one-on-one, whether lecturing or with your documentation, please make contact. No donation is required. Number four, if it has been placed on your heart to donate, regardless of the amount, please feel free to do so via Cash App. I've really sacrificed a lot of time preparing the videos, and I can only hope that you are taking advantage of said information. Number five, please share the channel videos with as many people as possible. The information you have witnessed thus far and will be witnessing from this moment on is electrifying. And yes, I am here to stay indefinitely. Okay, so you guys, it is going to get real good from this moment forward. You thought you saw some videos prior to, but you have never seen nothing like this before. I can guarantee this. So without further ado, let's begin. Today's focus: Public Law 93-595, an act to establish rules of evidence for certain courts and proceedings. You guys really want to listen to this video. It is going to be on point, okay? I'm doing this video because of the fact that a friend of mine brought it to my attention and asked a simple question. And I said, you know what? This is how I go from point A to point Z. By the time I got finished, his jaws dropped. He couldn't believe it. He was dismayed. Normally, when people speak about this particular subject, they don't go into the specifics. They just give you a template or whatever the case may be. But I am going to show you some serious specifics, and I'm going to give you some general ideas. You will be blown away regarding this information. I kid you not, okay? So I need you guys to listen up and prepare yourselves accordingly, because it is going to get real, real good. Okay, so let's go ahead and make our way down to the beginning here. Article 1, General Provisions. We're going to take a look at Rule 101, Rule 102, and Rule 103. Let's see what it says here. One moment. Okay, so right here, you're looking at Public Law 93-595. As stated before, let's focus on what? The highlighted area. I guess on your own time, you can go ahead and read the entirety of said public law, but I'm going to read the highlighted area. It is very important that you hear this. Okay, here it goes. These rules apply to actions, cases, and proceedings brought after the rules take effect. These rules also apply to further procedure in actions, cases, and proceedings then pending, except to the extent that application of the rules would not be feasible or would work injustice, in which event former evidentiary principles apply. Boom. Okay, you're like, wait a minute, Zen. Okay, you've read that or whatnot, but what does it mean? Let's see what it means. You know what it means. You know what's been going on in the courtrooms. You know exactly what's been going on in the courtrooms. So let's proceed. Okay, 101, 102, and 103. Let's take a look at those things here. Okay, so 101 scope, 102 purpose and construction, and 103 rulings on evidence. And by the way, you guys, I just want to say this to you right now. This is dedicated to all those who actually experience court, whether it's a traffic infraction, whether it's just a civil case, whether it's a criminal case, misdemeanor, felony, whatever the case may be. This is also dedicated to those who have been held in contempt of court. This is dedicated to all of you who've had these court experiences, proceeding experiences and whatnot. You are going to love this video. Okay, let's go. All right, so let's get down to here. Scope. These rules govern proceedings in the courts of the United States and before United States magistrates, to the extent and with the exceptions stated in Rule 1101. Rule 102, purpose and construction. These rules shall be construed to secure fairness in administration, elimination of unjustifiable expense and delay, and promotion of growth and development of the law of evidence, to the end that the truth may be ascertained and proceedings justly determined. Boom. Okay, that's 102. Let's look at 103. We're not going to read the entirety of 103. I just want to go ahead and touch bases on it. Okay, so Letter A, effect of erroneous ruling. Error may not be predicated upon a ruling which admits or excludes evidence unless a substantial right of the party is affected. And let's go here to number 2. I'm not reading number 1. I want number 2. Offer of proof. In case the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer or was apparent from the context within which questions were asked. As a matter of fact, now let's go back to number 1. Objection. In case the ruling is one admitting evidence, a timely objection or a motion to strike appears of record stating the specific ground of objection if the specific ground was not apparent from the context. Ooh, you guys, we got a serious problem here. Okay, so I'm going to go ahead and leave that alone, and we're going to move forward. Okay, so I did go ahead and demonstrate what did I read so far? Thus far, let's go back to the other page. 101, 102, 103. Now let's go to Article 3, Presumptions in Civil Actions and Proceedings. Now, I'm not going to focus too much on it. The reason being is because we know that this is what the what are they called again? Judicial officers practice in court in the proceedings, in the actions, in the cases, etc. All that good stuff. Okay, presumptions. This is what they do best. Okay, but I got something for it, and like I said, I got a little surprise. Of course, the veterans, like I said, have touched on this special subject, but have not delivered accordingly. But let me not say delivered accordingly. Let me just say that they have not explained it thoroughly, which I am going to go ahead and do so right here. Okay. All right. No disrespect to anybody. No disrespect intended. Okay. Let's move forward. All right. So let's go to Article 3, Presumptions in Civil Actions and Proceedings. Let's make our way to it right now. Let me just make sure that you're able to see the screen. Okay, let's go. So let's find Article 3. Article 2, nope, not yet. Let's go to Article 3. Article 3, where are you? Where are you? You guys bear with me, please. Oops, I skipped it, I guess. Okay, this is it. This is Article where's Article 3? Right here. I'm sorry, you guys. Okay, Article 3, Presumptions in Civil Actions and Proceedings. Rule 301, presumptions in general in civil actions and proceedings. In all civil actions and proceedings not otherwise provided for by act of Congress or by these rules, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption, but does not shift to such party the burden of proof in the sense of the risk of non-persuasion, which remains throughout the trial upon the party on whom it was originally cast. All right, this is what's going on. This is what's usually going on in the courtroom. Okay, a lot of presumptions, right? Relevant evidence and all that good stuff. Okay, so this is what they're doing in the court proceeding. All right, let's move forward. So now let's make our way to, Article 4, Relevancy and its limits. This is Rule 401, and then we're going to go to Rule 406, okay? Let's check it out. So I'm going to pause the recording so I won't have to keep scrolling down and wasting your time. One moment. Okay, now we are here with the Article 4, Relevancy and its limits. Rule 401, definition of relevant evidence. Okay, let's take a look at that here. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. This is what they're doing in the courts. You guys know this already. This is what they're doing. This is what judicial officers do best. Okay, I am breaking it down to you word for word. Read it again. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Okay, you guys, circumstantial. Think about what I'm saying right here, you guys. Presumptions. This is Article 4 regarding relevancy and its limits, right behind presumptions. Okay, moving forward. The next one we're going to go to is Article 5, privileges. My apologies. We need to go back to Rule 406. I forgot to go ahead and discuss this. Habit, routine, practice. Okay, check this out. Evidence of the habit of a person or of the routine practice of an organization, whether what corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove that the conduct of the person or organization on a particular occasion was in conformity with the habit or routine practice. Let me think about this for a second. Let me see. Let's see here. Usually there's a lot of things that goes on in the courtroom in regards to the habit or routine practice regarding a person, which is defined in law as such and such and such and such and such, and an organization is defined in law as such and such and such and such. So you guys put two and two together. It is a habitual routine that is being administered over and over again in the courtroom. I'm not talking about other organizations. That's easy. That's too easy. But I'm trying to get your focus on in regards to what I'm saying here. Again, habit, routine, practice. Evidence of the habit of a person or of the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, regardless, is relevant to prove that the conduct of the person or organization on a particular occasion was in conformity with the habit or routine practice. You think about that. I'm going to leave that alone. Think about that for a second. Okay, now let's go ahead and move forward to the next phase. Okay, Article 5, privileges. Okay, Rule 501, general rule, except as otherwise required by the Constitution of the United States or provided by act of Congress or in rules prescribed by the Supreme Court pursuant to statutory authority, the privilege of a witness, person, government, state, or political subdivision thereof shall be governed by the principles of the common law as they may be interpreted by the courts of the United States in the light of reason and experience. However, in civil actions and proceedings with respect to an element of a claim or defense as to which state law supplies the rule of decision, the privilege of a witness, person, government, state, or political subdivision thereof shall be determined in accordance with state law. Very, very interesting. I'm showing you guys all of this right now, so therefore you can start pondering and putting your notes together so you can start creating your documents accordingly. This is me conducting due diligence, of course, and sharing it with you. Trust me, you want to go ahead and take everything that I'm saying now in consideration. Let's move forward. Okay, so the next thing we're going to be focusing on is Article 9, authentication and identification. All right. Okay, Article 9, authentication and identification. Rule 901, requirement of authentication or identification. Okay, you guys, so let's go ahead and get into this real quick. All right, so A, general provision, the requirement of authentication or identification as a condition precedent to admissibility and satisfied by evidence sufficient to support a finding that the matter in question is what is proponent claims. And then also B, illustrations, by way of illustration only and not by way of limitation. The following are examples of authentication or identification conforming with the requirements of this rule. I'm going to skip everything and get you straight to the fire. Let's go to 7. Public records or reports, evidence that a writing are authorized by law to be recorded or filed and in fact recorded or filed in a public office or a purported public record, report, statement, or data compilation in any form is from the public office where items of this nature are kept. Number 8, ancient documents or data compilation. Evidence that a document or data compilation in any form, A, is in such condition as to create no suspicion concerning its authenticity. B, was in a place where it, if authentic, would likely be, and C, has been in existence 20 years or more at the time it is offered. 9, process or system. Evidence describing a process or system used to produce a result and showing that the process or system produces an accurate result. 10, methods provided by statute or rule. Any method of authentication or identification provided by act of Congress or by other rules prescribed by the Supreme Court pursuant to statutory authority. Okay, you guys, so we did go ahead and touch on that for a second. Now let's go to what? Article 10, contents of writing, recordings, and photograph. Okay, that is Rule 1002, requirement of original. So let's go ahead and take ourselves to that area. Wait a minute, you guys. I want to go to Rule 902 real quick. I just need you to focus in regards to what I am showing you at this particular time. Let's take a look at eccentric evidence of authenticity as a condition precedent to admissibility is not required with respect to the following. Okay, let's scroll down. So we're not going to read this in its entirety. Let's check it out. Number 4, certified copies of public records. Number 5, official publications. Number 6, newspaper and periodicals. Number 7, trade inscriptions and the like. Number 8, acknowledged documents. Number 9, commercial paper and related documents. Number 10, presumptions under acts of Congress. Any signature, document, or other matter declared by act of Congress to be presumptively or prima facie genuine or authentic. Yes, you guys heard it loud and clear. So wait a minute, what does this remind me of? Hold on. Wait a minute, I had to go ahead and think about this for a second. You guys, let me go ahead and bring this up real quick. Everyone, remember this? Little and Brown's edition of Laws and Treaties, Admissibility and Evidence. 113, the edition of the Laws and Treaties of the United States published by Little and Brown shall be competent evidence of the several public and private acts of Congress and of the several treaties therein contained in all the courts of the law and equity of maritime jurisdiction and in all the tribunals and public offices of the United States and of the several states without any further proof or authentication thereof. Boom. Okay, let's go ahead and move forward back to what we were talking about. Let's stay on track. Okay, again, you guys, I had to really pause the video and resume recording. Reason being is because there's a lot to scroll down to, so I didn't want to go ahead and bore you with the scrolling, upwards or downwards, etc. Okay, here it goes. Rule 1002, requirement of original. To prove the content of a writing, recording, or photograph, the original writing, recording, or photograph is required except as otherwise provided in these rules or by act of Congress. Just showed you an example previously, okay? So otherwise. Okay, so let's go ahead and take a look at the next thing we're going to be viewing here. Okay, so we did Article 10. All right, let's go to Article 11. Article 11, let's check it out. Miscellaneous rules, here we go. Courts and magistrates. This is again, Rule 1101, applicability of rules. Letter A, courts and magistrates. These rules apply to the United States district courts, the district courts of Guam, the district court of the Virgin Islands, the district court of the District of the Canal Zone, and the United States Courts of Appeals, the courts of claims, and to United States magistrates in the actions, cases, and proceedings, and to the extent hereinafter set forth, the terms judge and court in these rules include United States magistrates, referees in bankruptcy, and commissioners of the Court of Claims. B, proceedings generally. These rules apply generally to civil actions and proceedings, including admiralty and maritime cases, to criminal cases and proceedings, to contempt proceedings, except those in which the court may act summarily, and to proceedings and cases under the Bankruptcy Act. Okay, you guys, so there you have it. So now we're going to go ahead and get into something real nice and thick here. All right, in regards to this information. Now, over here, you see at the bottom here, these are what the attorneys or bar members or judicial officers and judges, of course, and they practice a lot of, they're one and the same, of course, where we talk, they go by preliminary questions, question of admissibility, generally, relevancy, condition of fact, presumptions, relevant evidence, methods of proving character, witnesses, opinions, and expert testimony, and hearsay. We already know this. This is what they do. Again, preliminary questions, questions of admissibility, generally, relevancy, condition of fact, presumptions, relevant evidence, methods of proving character, witnesses, opinions, and expert testimony, and hearsay. Think about what I just said, you guys. There is one thing I have never seen an attorney do successfully. Never seen it done in the interest of a client. And here we go. And that is Article 2, Judicial Notice. Rule 201, judicial notice of adjudicated facts, letters A through G. Let's go to it. Okay, everybody, audience, here it goes. Permission to treat this video as a hostile video. Please, audience, say yes. Okay, yes, thank you. Here it goes. Article 2, judicial notice. Rule 201, judicial notice of adjudicated facts. A, scope of rule. This rule governs only judicial notice of adjudicated facts. Here we go. Here we go. B, kinds of facts. A judicially noticed fact must be one not subject to reasonable dispute in that it is either generally known within the territorial jurisdiction of the trial court or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Boom! Cannot reasonably be questioned. Capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Boom! Let's go. C, when discretionary, a court may take judicial notice whether requested or not. May take, when it comes to discretionary, you guys. Let's look at D. When mandatory, a court shall take judicial notice if requested by a party and supply with the necessary information. Boom! Pay attention. When mandatory, a court shall take judicial notice if requested by a party and applied with the necessary information. Letter E, opportunity to be heard. A party is entitled upon timely request to an opportunity to be heard as to the propriety of taking judicial notice and the tenor of the matter notice. In the absence of prior notification, the request may be made after judicial notice has been taken. Excuse me, let me clear my throat. F, time of taking notice. Judicial notice may be taken at any stage of the proceeding. Boom! Letter G, instructing jury. In a civil action or proceeding, the court shall instruct the jury to accept as conclusive any fact judicially noticed. In a criminal case, the court shall instruct the jury that it may, but it is not required to accept a conclusive any fact judicially noticed. Think about it, you guys. Think about it. Think about what was just said here. You got to go ahead and take what? Judicial notice. Judicial notice must be done. The reason why I've provided the information prior to me reading this is because I need you to see how things work. I need you to see the evidence that needs to be submitted, the proof, the authenticity of it, whether authentic or not. You know what I'm talking about. Public statutes at large. We're talking about the Constitution. We're talking about Articles of Confederation, all that good stuff, okay? We're talking about record made during the regular course of business. We're talking about government records, papers, and copies. We're talking about concealed, removed, or mutilated generally, all that in regards to the public statutes at large. This is why I provided the videos prior to leading up to this moment here, because you need to see that everything is in sync, especially if you're experiencing a proceeding, a case, civil action, criminal proceeding, the whole 9 yards. There's something that must be done prior to moving forward. That's another video. Not doing it here. Okay, so judicial notice, you guys, is the hammer. So now that I have shared this with you, let's go ahead and focus and utilize a state for an example. Okay, so let's do the what? Let's do the state of Florida, United States. How about that? Let's check it out, you guys. Let's go to it right now. Okay, so as you can see here, we have Title VII evidence here, Florida. Right here, it's the same thing. Everything that's highlighted, I've already read. In regards to the public law, everything has just been what? Transferred down accordingly, okay? So everything that you see that's highlighted, it's the same principle. Same principle. Do not get confused. Look at it very closely. Do not get confused. This is in every state, you guys. Every state. Every state. Pay close attention to the highlighted ones. Every state. Come on. Come on. Every state. Look at it. Come on, you guys. Look at this one. Highlight it. Highlight it. Here it says, we already know about that. I had to highlight that so you can see what's going on. Self-authentication. Look at this one. Look at 90.901. Requirement of authentication of identification. Every state. No excuses. Requirement of originals. Remember, we spoke about that already. Public record, look at this, look at this. Okay, so now I'm gonna go ahead and dive a little deeper. You guys bear with me, bear with me. Okay, here we go. Look at this, 90.103, Florida statutes, okay? So look at number 2. Look at number 2. This act shall apply to criminal proceedings related to crimes committed after the effective date of this code and to civil action and all other proceedings pending on or brought after October 1, 1981. See? Criminal proceedings as well as civil, okay, actions. Same thing, you guys. It applies all over the place. Nothing changes. Your state has the same thing under this special law, local law, special legislation, i.e. statutes. All right, let's move on to the next one. All right, you guys, check it out here. Again, Title 7, Evidence, Evidence Code, Rulings on Evidence. Check it out. 90.104, a court may predicate error, set aside or reverse a judgment, or grant a new trial on the basis of admitted or excluded evidence when a substantial right of the party is adversely affected, and A, when the ruling is one admitting evidence, a timely objection or motion to strike appears on the record stating the specific ground of objection if the specific ground was not apparent from the context, or, well, we don't need to strike anything, or we don't need to go ahead and expunge it, or we don't need to seal it, because, of course, when it comes to government records, papers, and copies, you don't want to do that. When it comes to records made during the regular course of business, you don't want to do that. So what needs to happen, you guys? Judicial notice, apply the proper statutes at large pertaining to what I just said. But let's go ahead and move forward. Okay, so stating the specific ground of objection if the specific ground was not apparent from the context, or B, when the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer or proof, or was apparent from the context within which the questions were asked. Okay. You guys need to listen to that very closely. If the court has made a definitive ruling on the record admitting or excluding evidence either at or before trial, a party need not renew or an objection or offer or proof to preserve a claim of error for appeal. Boom! Think about that. How many times has that happened? Uh-oh, we got a situation here. Look at number 2. In cases tried by a jury, a court shall conduct proceedings to the maximum extent practicable in such a manner as to prevent inadmissible evidence from being suggested to the jury by any means. Number 3, nothing in this section shall preclude a court from taking notice of fundamental errors affecting substantial rights. Hello, even though such errors were not brought to the attention of the trial judge. We're talking about the state constitution. We're talking about a lot of things here, you guys. Okay, but I'm going to show you where this number 3 coincides. Well, this ruling on evidence coincides with what I'm about to show you right now. One moment, please. Okay, check this out. Here we go. 90.201. Matters which must be judicially noticed. Must be. Must. It's no you decide whether or not to do it or not, or to recognize it in court. Must. Here it goes. A court shall take judicial notice of what? Number 1 is the most important one. Decisional, constitutional, and public statutory law and resolutions of the Florida legislature and the Congress of the United States. Boom. Number 2, Florida rules of court that have statewide application, its own rules, and the rules of the United States courts adopted by the United States Supreme Court. Boom. Number 3, rules of the Court of the United States Supreme Court and of the United States Courts of Appeal. Boom. But number 1 supersedes them all. Documentation. Records made during the regular course of business, government records, papers, and copies, removal, concealment, and mutilation generally. How about that? Let's talk about it, you guys. Let's talk about that. You know what? Let's continue. Getting too excited. Let's continue. Let's take a look at 90.406, routine practice. Okay? Evidence of the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is admissible to prove that the conduct of the organization on a particular occasion was in conformity with the routine practice. Uh-oh. So you mean to tell me there's a routine practice going on? We're not talking about only in regards to whatever civil action comes in, whatever criminal proceeding comes in and whatnot. What about the court per se? There's a routine practice that they do. Well, you know, whether they intentionally submit evidence, omit evidence, you know, expunge it, strike it, whatever they want to do, moot, whatever they want to go ahead and call it. Maybe, maybe not. I don't know. What happens if you go ahead and make it a judicial notice? You can't do it, huh? Right. So let's go ahead and move forward, you guys. Okay, so now we're here, 90.502, lawyer client privilege. So just by any chance you decide to hire a lawyer, go ahead and do something for you. I don't know what they're going to do for you. That's a presumption, I guess. But anyway, let's go ahead and move forward. So let's focus on the highlighted area. So check this out. Look at number 4. There is no lawyer-client privilege under this section when the service, look at letter A, the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew was a crime or fraud. Interesting. Letter C, a communication is relevant to an issue of breach of duty. So if I tell the lawyer to do a judicial notice, you think they're going to actually do it? Is that considered a breach of duty, especially if you have the evidence, irrebuttable evidence, evidence that cannot be questioned regarding public law or the Constitution, etc.? I don't know. I'm just speculating. Right? Right. So let's go back. A communication is relevant to an issue of breach of duty by the lawyer to the client or by the client to the lawyer arising from the lawyer-client relationship. Okay, you guys. So that's something you really need to think about, excuse me, in regards to this section here. Like I said, it's the same thing. Whatever was said in public law, it's going to go ahead and transfer on down to the statutes by way of the special law, local law, special legislation. Just pay attention to it, connect the dots and see what happens. I'm showing you what can be done depending on what is submitted by way of a judicial notice, by way of evidence. Okay, let's not just say judicial notice, by way of evidence. Okay, and it cannot be unrebutted. Pay close attention. You've already seen the previous videos. If not, you need to go see it in regards to what I'm speaking about regarding public laws. Seriously. Okay, moving forward. So there you have it, you guys. I was able to prove beyond a reasonable doubt that the information coincides, public law and the statutes. Remember, we're talking about the state of Florida, United States, okay? And I just showed you beyond a shadow of a doubt that this stuff is real here. There's ways you can go ahead and do what needs to be done regarding these court cases. Yes, we're going to talk about that in the next video. I just want to go ahead and give you the structural foundation pertaining to what we're speaking about, which is the evidence. I showed you the evidence regarding state of Florida. I showed you the evidence regarding public law, okay? So I just want to go ahead and share that with you so there's no miscommunication or no type of outlet regarding the information. It's right here. There's no hearsays or whatnot. It's all here. You have the information that is needed in order to bring any court case to its knees. And we're going to talk about certain things that you can do in the next video pertaining to this matter here, okay? So I hope you enjoyed it. Again, like I said, let's go back to the other one here. Like I said earlier here, if there's a particular video you need me to go ahead and create, definitely go ahead and let me know. That's number one. If you have any questions and you need a bit more clarity regarding any type of information, whether it's a lecture or whether it's basically documentation, hit me up. Let me know. I said everything here. If you feel it upon your heart to go ahead and donate, go ahead and do so or whatnot. Definitely go ahead and share this information with others, especially my channel and videos pertaining to their such. And of course, like I said, I am back and I'm here to stay. I'm not going anywhere. So I hope you enjoyed this presentation. I try to make it as short as possible and effective as possible. I know people are going to have questions, but that's what I'm here for. So I look forward to seeing you guys next time. Have a great day. Zen out.